Welcome to episode 23 in the first season of Justice Center Weekly, the video cast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me today is lawyer Marty Moore, who's going to bring us up to date on a number of cases in British Columbia involving church services held during COVID lockdowns. Marty, I understand that BC churches and pastors have been back in court this week. Can you bring us up to date?
Yeah, you bet, Kevin. Yeah, this is maybe a surprise to some of our listeners who probably were familiar with the fact that the Supreme Court of Canada denied our leave application to challenge the constitutionality of these orders, which prohibited in-person worship services from November 2020 to May 2021. So we're still representing a number of pastors in the province of British Columbia who are being prosecuted for going to church during that time period. And so this last couple weeks here, we've actually been back in court on those prosecutions because there's not simply the charter issues under Section 2 and whether freedom of conscience and religion was going to protect these pastors. We still have a lot of other matters to raise. And one of those matters that was actually addressed in a decision rendered by Judge Ormanston on September 6th was a question of whether or not these churches can raise an abusive process application against the prosecution and against actually the Public Health Office of British Columbia for bad faith that should lead the court to dismiss these charges against them. Because what we have here in these contexts, Kevin, and I think we've maybe gone over this before, was not only did the public health officer just categorically prohibit worship services, both indoors and outdoors. You couldn't meet in person for worship in British Columbia for almost 6 months. But she, in fact, throughout that entire time period, was telling one particular religious group in the province that, no, it's fine for you to meet together. And so that issue and some other actions of the Public Health Office, by only selectively letting some religious faith groups meet in person and not telling other faith groups that they could meet in person, but rather issuing just a general prohibition, that question is still a live question. Whether or not that violates your freedom of conscience and religion, there's something wrong about that. We say that is an action done in bad faith, not for a medical purpose. We don't even know what purpose it is. So we brought an abusive process application on one of the 19 remaining charges against these particular churches in the Fraser Valley. And the government of British Columbia came back and said, no, you can't bring that application. It should be summarily dismissed. And so the court took a careful evaluation of just the preliminary evidence that we brought. And in that preliminary evaluation, the judge noted that there is some evidence that the Public Health Officer of British Columbia preferred some faith groups above others. And that is, of course, very concerning from a legal standpoint. And it is on that basis that we're going to be now proceeding with the court's permission to argue that these charges against churches in British Columbia for meeting should be dismissed as an abusive process. It violates, in our view, some fundamental principles of the rule of law. When you have a government bureaucrat who's making, in fact, orders for everyone in the entire province, granting selective permission, but only to some groups and only on some occasions. In fact, if some of our BC listeners might be part of, faith groups, whether that's any number of faith groups, we're not aware of any other faith group except one that even had responses to their requests sent in to Dr. Henry's email in regard to asking for asking for accommodation of their right to worship in person. But one particular group was getting that permission throughout the entire time period. Doesn't sound right. We think we need to have more information. And so we actually asked the court to allow us to cross-examine Dr. Henry and also the deputy Provincial Health Officer, Dr. Brian Emerson. We thought that there's a lot of questions that are raised about their conduct. How do you say it's unsafe for everyone to meet for worship, but then tell another group that it is safe to meet in person for worship? And how do you let one group, how do you respond to only one faith community and not respond to other faith communities? What's the difference? For example, some of the individual and the evidence that we have in the court is that, a church community would request accommodation of their rights on December 6th, and all they got back was an auto reply, and didn't get a response back till May of the next year. They requested accommodation on December 6th, didn't get a response until May of the next year, and the response was, sorry, we're just too busy. And of course the public health officer was busy. It's a province of 4 million people, and you've just, prohibited all of them from going to their respective houses of worship. Our understanding now is that there's 46,000 requests made of Dr. Henry through that just one email address. And she was supposed to be answering all of those in a timely fashion. In fact, she didn't, except for one group. And they seem to get special permission. And so that's part of the basis. There's a lot more evidence to go through there, but the court has said you can go forward with your application, but at this point, the court is saying we're going to allow the provincial health officer's decisions to speak for themselves. You're not going to be able to ask her any questions about those, and also not going to be able to ask her any questions about what her lawyers may or may not have told her, whether they were involved in particular conversations. We understand that. However, there's some questions about a more general take on this issue, and really only the provincial health officer can explain that. But we will be setting a schedule now to bring forward probably a mountain of evidence that shows this selective treatment, which, unless it can be explained in some rational way, which is beyond me, I believe is indicative of an abuse, not only of the provincial health officer's authority, but also of our legal system to be prosecuting these churches in those kind of circumstances.
So they're allowing you to make the application, but they're also saying that the public health officer doesn't have to answer the questions that are raised by the application. So I'm not sure if I understand the process here.
Yeah, so the application is really to say to the provincial court, in these circumstances, and based on the bad faith conduct of the government decision maker rendering these orders that we are now subject to prosecution under, the prosecution should be dismissed, because really prosecuting people in these circumstances brings the whole system of justice into disrepute. It casts a shadow on what should be a process equally applied to all. And when that is not present, there's some serious concerns that the unequal treatment, which there is some evidence of, the court noted there is some evidence of that. The government lawyers couldn't brush that away, despite arguing in May for 4 days. We had a hearing for 4 days as to whether or not we could just proceed with this application. Now we'll see how long the court time it takes now to argue this application. But very serious concerns, because, for example, I'm aware that the Archbishop of Vancouver made a request for Catholic churches to be accommodated to meet in person with, very strict safety protocols. Did not get a response and had to bring a court application. Well, how does that align when, all of the Jewish synagogues in the province were getting responses within a couple days and permission to meet in person in tents throughout the entire time period that in-person worship services were prohibited, and in fact even were granted permission to meet indoors, until that was uncovered actually in a court case where the provincial health officer was saying, "Oh, look, I'm giving these three churches that are before the court just 2 days before the hearing, I'm going to give them permission to meet outdoors, because that's the best I can do for them." And she only did it for those three churches that had actually sued her on the constitutionality of her orders. But 2 days before, she'd allowed all of the synagogues in the province to meet indoors. But I think she thought that was a secret. but it was uncovered in the court proceedings. And then what did she do? She revoked permission to the synagogues to meet indoors and then forced them to meet outdoors as well. This kind of conduct raises serious questions about the good faith and whether the powers of the office were being exercised with integrity and in line with public health purposes, or were they being in fact exercised in bad faith?
Well, maybe you could just explain what bad faith means here. I mean, I'm pretty sure it's self-evident, but it obviously has some kind of legal import here. Is that a way of saying lying, or is it just acting in a way that unbecoming of a public health official or something? I'm not sure what exactly bad faith means legally here.
Yeah, well, I think the essence of it is that the provincial health officer is granted particular authority to protect the health of British Columbians. And of course, that would be protecting the health of British Columbians regardless of whether they're Orthodox or Muslim or Jewish or Catholic or other evangelical denominations. It wouldn't matter. Every person's health is equal. And there's also whether you're sitting together to talk about the Torah, the Quran, or the New Testament, the subject matter shouldn't be a determining factor of the health implications. And if necessary, we will be bringing expert evidence to tell the court that is in fact not a health determining factor, the subject of discussion. So the question of bad faith it's a bit of a catch-all for what all of us would understand based on common sense would be something outside of the delegated authority that a provincial health officer would hold. And of course, for example,
but it differs some. Oh, sorry.
Oh, go ahead, Kevin.
I was just going to say it differs somewhat from a charter challenge. Then, we're not talking about charter violations and they're acting in bad faith against charter rights.
Right. Yeah. In regard to the charter case, that is no longer something that the courts are allowing these pastors to pursue. They heard it in a judicial review, denied it. They said it was reasonable from the court's review, and the courts are not allowing us to put forward evidence in regard to that. But, your listeners will be familiar with the Alberta case recently, where in our charter challenge in Alberta to the public health officers' orders, we also had the opportunity to question Dr. Dina Hinshaw on the stand. And it was in that questioning that we learned that Dr. Dina Hinshaw was not rendering medical orders. She was enacting the political decisions of the governor and council in Alberta, Jason Kenney and his cabinet. And it's also interesting, Dr. Bonnie Henry, in fact, wrote a book in which she indicates that in her line of work, she is responsive to the political opportunities of the moment, and that is a very important part of her job. So the question, which may never be answered if we don't have the opportunity to cross-examine Dr. Henry on these points, and at this point we do not, is were you operating on the basis of public health concerns, or were there political questions engaged in these decisions? Because the Public Health Act gives public health officials the ability to address public health concerns. Policy and political questions are not there. So, of course, in Alberta, we have an E. coli outbreak, and we are now seeing a provincial public health officer getting involved in something they actually should be involved in. A particular food preparation site not being maintained up to standards of health and causing serious illness and risk to children. That is where the provincial health officer's authority should be there. Restricting protests and worship services, was that ever a good idea for public health officers to be making those decisions? Were those ever health decisions, or were they all political decisions? These are worthy questions, I think, for legislators to take up and to figure out whether their public health acts should really be called political and health acts, because I think what we found and what we can see even with just common sense, shows that there's a lot of politics behind the scenes on these things. But let me move on because I don't want to take too much more time with that. That application will be proceeding not only on behalf of Pastor John Koopman, but other churches in the Fraser Valley who are still facing prosecution will be joining and filing applications as well. So yeah, there's other charges obviously facing churches more than just John Koopman's matter, and we'll be joining these other charges now, raising similar questions about whether or not the prosecution of the pastors and churches in these circumstances is also an abusive process. Stepping back a little bit, Kevin, I've been involved in this situation in British Columbia on whether or not there's a fundamental right to worship and just advising and also representing churches there since 2020. Originally, we saw, dozens of churches charged with hundreds of charges. Estimated liability would be in the hundreds of thousands of dollars. We have now this week finally moved forward past a lot of the preliminary questions, including, questions such as, did this church host a service or not? Were people there? And through our representation, we've seen the Crown drop most of those charges, and now the estimated total liabilities round about $10,000 on all of these churches combined, rather than the hundreds of thousands of dollars of liability. But we're not giving up the fight yet either. There's still, like I mentioned, these very real concerns. So we were in court for the last couple days in Abbotsford, addressing some of those preliminary questions. The factual questions, which are normally a very big concern in most trials, who did what and when. On these church service situations, these pastors weren't in a position or weren't seeking to deny, and in fact had sworn affidavits that they did hold in-person worship services. And so they are, recognizing that fact. The court, in fact, said, well, I'm noting that you're not denying this. In fact, you're admitting that you held in-person worship services. So the court was finding them guilty of violating the provincial health orders this week, not entering convictions because we are bringing these other applications, but guilty of violating a provincial health order that applied regardless of the safety protocols in place. And the court noted that on the record. It wasn't the conduct at the services that was prescribed or prohibited. What was prohibited was the purpose of gathering for worship itself. And the court noted, under these orders, the amount of people that could gather in person for worship was 0 under these orders, which is quite shocking when you can think of the government targeting the religious purpose. So you could gather with 10 people for a baptism, but if you gathered for worship, you could have 0 people there. And it's, just going through this process in court this last week, and just noting that is what our judicial system is being called upon to do, is to find pastors guilty of violating a prescribed purpose that the public health officer prohibited. It is something that is deeply concerning to me. And so my view of this is that, Dr. Henry, she prohibited in-person worship gatherings not based on actual transmission risk, but based on the very purpose of gathering for worship. And it's deeply concerning that our legal system continues to be used to prosecute violations of such perverse orders, in my view, nearly 3 years after those orders were made and 2.5 years after they've been rescinded. And we're going to continue to defend these pastors and churches against what we believe to be an abuse of provincial health authority and also an abuse of our legal system. One of the other applications that we will be filing is what's called a Jordan application after the Supreme Court of Canada case in R.V. Jordan, which addressed the right that people have to be tried without unreasonable delay. And in provincial court, that time period for unreasonable delay is 18 months. And some of these charges are dating back from November of 2020, and they're just getting their court dates now. And so we will be raising that question in court as well, saying, is this delay in in the trial of these matters, is that in alignment with the right to be tried without unreasonable delay? We will be filing those applications shortly as well. Of course, there's this thing called COVID in which courts themselves were shutting down their processes, but it's a question that should be raised. The presumption is that after 18 months, a matter has suffered unreasonable delay. That's the ruling from the Supreme Court of Canada, and some of these matters have been, now not gone to trial in 30 months. So we will be raising that question as well. So that's the little update, Kevin, from the cases in British Columbia, where we continue to represent BC churches and pastors being prosecuted for following the dictates of their faith and gathering together safely in person. These are entities that they tried as much as possible to comply with every requirement out there, but when it came to violating their sincerely held religious belief that they needed to gather in person for the worship, that was something they could not do in good conscience, and now are continuing to be prosecuted for it. So we'll give you updates as these matters move along, and I expect some of them might go to hearing for unreasonable delay later this year, possibly December.
Okay, just on the Jordan application, that's not a drop deadline, 18 months. Obviously, it still has to be adjudicated as an application. In other words, they have to look at the circumstances. Is that essentially what happens?
Yeah, normally this would be a drop deadline, but there's the question of, well, what do you do with the issue of COVID? And I think that's going to be the live concern that is going to be raised. Was the prosecution diligent in getting these matters to trial in a reasonable period of time? And that will be the question that the court is being asked to address.
Okay, good. And you say it's going to go to court probably later this year.
Yes, we will be setting a schedule at the end of this month with the judge to try these next two applications on behalf of these pastors.
Okay. Were there any other ticket cases in BC that you wanted to mention? I noticed that we did have a press release on one just recently. Maybe you just want to remark on that.
Yeah, no, that's all the ticket cases that are ongoing in British Columbia right now. In regard to the COVID orders, there are some Quarantine Act matters that we continue to represent people on, and seeing charges dropped in those matters. But thankfully, not as many COVID orders on other issues. Of course, COVID orders in regard to protests were struck down as unconstitutional in British Columbia, but these are the ones we continue to represent on in regard to worship services.
Okay, great. Thanks, Marty, for bringing us up to date on this. I do appreciate you taking the time, and I hope to speak to you again real soon.
Thank you, Kevin.